Good morning, Professor. My name is Ranjit Singh and I am from Group G is going to introduce the facts, introduce the parties and introduce the case. So initially giving the overview of the case is about on a share purchase agreement which is the main issue in this matter between Fairstone Financial Holdings and Deo Bank of Canada. The Fairstone and Deo signed a contract on February 18, 2020 wherein Deo committed to buy Fairstone Company's shares. The closing date of the agreement was set for June 1, 2022, 20, sorry. But on May 27, 2020, Deo notified Fairstone that it would not be closing as scheduled, citing four covenants in the agreement: the ordinary course covenant, the the next one is the amortization event coordinate, the material adverse event coordinate, and the last one is the access to informational covenant that purposely permitted Deo to postpone closing. The World Health Organization announced the COVID-19 pandemic on March 11, 2020, and its effects are on the center of the controversy. Moreover, Duo asserted that it was able to back out of the agreement since the pandemic activated these covenants. Fairstone responded by requesting specific performance, which meant they wanted the court to order Duo to finish the deal as planned. The court decided in Fairstone's favor, concluding that it was not allowed to defer closing the purchase by using the covenants mentioned by Deo. So Deo was required by the court to fulfill the terms of the share purchase agreement, which means that they had to finish buying Fairstone companies. The interpretation of the covenants, in particular the material adverse effect clause and the questions of whether Fairstone conduct during the pandemic was consistent with its regular course of business or ultimately determined the outcome. The court found that Fairstone was not disproportionately affected by the pandemic, in fact, in comparison to other community. So this was the overall case which become the main agreement of issue in that. Now I'm going to introduce the parties. There are several parties which took part in this. The first one is Fairstone Financial Holding. Fairstone Financial Holding is the Canada largest consumer financial company targeting near prime borrowers with over 3 billion assets. It has been in operating since 1923. The next party is JC Flowers and Wade Partners. The current owner of the Fairstone is Flower is a USA based private investment firm managing approximately 6 billion in assets. Wade Partners is a USA based global alternative investment firm with approximately 14 billion in asset. Now the third one is Duo Bank of Canada, a privately owned schedule Canadian bank offering product and services including credit cards, related protection services, deposits, and reward programs. Duo Bank participated in the binding process to purchase Fairstone. So my fourth party which took place in this case is Centerbridge Partners LP, a new private investment firm based in New York and London, managing approximately 27 billion in capital. It funded Duo Bank bid to purchase Fairstone along with the Ontario Teachers Pension Plan and Stephen Smith. The fifth one is Ontario Teachers Pension Plan Board, which also took part in this case. One of the Canada largest pension funds with over 200 billion in asset under management and also involved in funding in Duo Bank purchase. The last and the sixth one is Stephen Smith, a highly experienced entrepreneur in the financial service industry, chair and CEO of First National Financial Corporation, and a director of the Canada Infrastructure Bank and EL Financial Corporation. These are the parties which are involved in a competitive binding process, resulting in a signed share purchase agreement for this case.
My name is Vrinder Singh and my student ID is 4378734, and I'm start with the factual events. Number 1 is share purchase agreement on February 18, 2020. Fairstone Financial Holding Inc. and its subsidiaries signed a share purchase agreement with Duo Bank of Canada. Duo Bank agreed to purchase Fairstone business with the closing date initially set for June 1, 2020. On number 2, COVID-19 pandemic. The World Health Organization declared COVID-19 a pandemic on March 11, 2020. The pandemic led to unprecedented economic conditions affected business globally, including Fairstone. Number 3, Duo Banks notice on May 27, 2020. Duo Banks informed Fairstone that it would not close the transaction on June 1, citing for convents in SPA as grounds for avoiding closures, materials, adverse effect, ordinary courses, amortization events, and access to information. Fairstone's response in response to Duo's notice to close non-closing, Fairstone filed an application for specific performance seeking to compel Duo Bank to fulfill the terms of SPA. Procedural events, litigation initiations. Fairstone initiated a legal proceeding seeking specific performance of SPA, while Duo Bank began parallel action laying the ground for legal dispute regarding the validity of the agreement and potential branch judicial assignment assessments. The court has examined the argument presented by both parties concerning the alleged breaches of the convents listed in SPA. The key issue reviewed including the material adverse effect caused by pandemic with the Fairstone operated in the ordinary course and the likelihood and amortization events. Conclusion and judgment. In judgment delivery on December 2, 2020, the court ruled in favor of Fairstone, ordered Duo Bank to specified performance the shares purchase agreement. The court found none of the convents cited by dues and reason non-closure were breaches. Thanks.
Hello, my name is Amripal Singh, and now I'm going to talk about the rule of law which is applied by court. The first rule of law is a material adverse effect. And the court assessed whether a material adverse effect had occurred as defined in the share purchase agreement. The definition of a material adverse effect include converse for global emergencies and changes in market conditions such as those caused by COVID-19 pandemic. And the second rule of law is ordinary courts convent. And the court evaluate whether Fairstone operate outside the ordinary course of business during the interim period between signing and closing, taking into consideration changes made in responses to the pandemic. And the convent required that the business operations were consistent with the previous parties, allowing for necessary adjustment during economics downturn. And the third rule of law is amortization event. The court examined whether there were any conditions that would respond reasonably by expected to result in amortization event impacting the financing document related to Fairstone's loan portfolio. And the last one is access to information convent. And the court looked at whether Fairstones failed to provide necessary information as required by access convent. So this was my points. Thank you.
My name is Harpreet Singh, and today I want to tell you about the decision. The court ruled in favor of the Fairstone, determining that No material adverse effect had occurred since the pandemic's impact was scraped up from the MAE definition in the SPA. And the second one is Fairstone's action were within the ordinary course of businesses. The court found that the modifications were consistent with the past practices and necessary due to economic circumstances caused by the pandemic. Third one is there was no reasonable expectations of an amortization event. The evidence suggests that the Fairstone had successfully managed its portfolios and no amortization event had occurred or was acceptable at the time of the trial. And the fourth one is Duo Bank had no adequately shown the Fairstone branch the access to the information covenant. The extensive demand for information appeared to be excessive or somewhat pretextual, aimed at avoiding the obligations under the SPA rather than the fulfilling genuine information need. As a consequence, the court ordered Duo Bank to specify perform the SPA, requiring them to close the transaction with the Fairstone. The judgment upheld the original term of agreement, emphasizes the informants of the contract despite economic challenges, unless expressly.
Good morning everyone, my name is Praneet Kaur. Today I am going to speak about the issues that was in case. Starting with the first issue, interpretation of the material adverse effect. Whether the impact of COVID-19 constituted on a material adverse effect MAE under the terms of the acquisition agreement between Fairstone and Duo Bank, the court has to determine how to interpret the MA clause in the light of the unforeseen global pandemic. Second issue, force majeure and COVID-19, whether the pandemic triggered any force provisions in the contract excusing either party from their obligations. The court had to consider if the pandemic could be classified as a force majeure even and what the implications would be contract performance. Third issue was timing and closing of the transition, whether the buyer Duo Bank could delay or terminate the acquisition based on the timing of the transition and the changes brought by the pandemic. The issue involved interaction of the contract provision regarding the closing date and the condition under which the buyer could refuse to close the transition. Fourth, good faith in the contractual performance, whether both parties acted in good faith in their contractual obligations in the light of the challenges posed by the pandemic. The court examined whether the actions of the Duo Bank were consistent with the duty of the good faith in the performance its contractual obligations. Fifth, applications of the legal precedents. How previous legal precedents relating to the MA clause and the force majeure should be applied in the unique contracts of the global pandemic. The court has to determine whether the existing case law provided sufficient guidance for resolving the dispute in the case. Sixth was allocation of the risk. The court has to consider how the acquisition agreement allocate risk between the parties in the contracts of force in events like COVID-19 pandemic. This involved examination whether the agreement placed the risk of the adverse economic impacts due to the pandemic on the Fairstone or Duo Bank. Seventh, causation of the alleged ME. The court needed to determine whether the alleged material adverse effect was directly caused by the COVID-19 pandemic or if it was due to the other facts. These issues required carefully examination of the causal link between the pandemic and the adverse financial condition cited by the Duo Bank. Eighth, buyer's termination rights. Whether Duo Bank had the right to terminate the agreement on the alleged ME and the other conditions that were affected by the pandemic. The court has to analyze the specific termination provisions in the contract and how they applied in the light of the pandemic. Ninth issue was mitigation of Ninth issue was the mitigation effects, whether Fairstone had undertaken reasonable efforts to mitigate the impact of the pandemic on its business and how they affect influenced the integration of the ME clause, the court considered whether Fairstone actions played a role in the changes by the due bank. Next point is the interpretation of the specific clause. This case involved detailed interpretation of specific clause within the equation agreement, such as those relating to the representation of warranties and conditions precedent. The next is impact on the business operations. The court examined the impact on the pandemic on Fairstone business, whether these changes were enough to be considered a material adverse effect. Thank you.
I will discuss the case of Have versus MS 2004 SKUB 34, a notable decision from Saskatchewan Queen Beach, which provide the significant insight into the principle of contract law and the doctrine of the mistake. The case overview. The central issue revolved around a contract for the sale of a business. The plaintiff Hayes sued the defendant MH, alleging that MH had breached the contract by failing to transfer the business as agreed. The core of the dispute was whether a mutual mistake about a fundamental term of the contract could allow one party to void it. The court analyzed and rationalized the doctrine. The court examined the doctrine of mistake, which can render a contract void if both parties are mistaken about a fundamental aspect of the agreement. Here, HH and MH were mistaken about the nature of a business asset, and he claimed that MH misrepresented the business value and operation status, leading to the dispute over the contract validity. Second, mutual mistake. A key aspect of this case was the mutual mistake regarding the business condition. The court highlighted that for a mutual mistake to the invalidate a contract, the mistake be about a material fact that has essential to the agreement. In this case, Hay and MH had both misunderstood critical element concerning the business operation, which was deemed fundamental to their agreement. Legal principle and precedents. The court relied on established principle of the contract law to resolve the issue, specifically the principle that a contract may be rescinded if both parties were mistaken about a fundamental fact was applied. The court cited precedent were mutually mistaken about the essential terms justified void contract. For instance, in Cairns versus Equitable Life Insurance Co. 1990, WWR 287 sask.c.a, it was established that mutual mistake must pertain to a fact that significantly affect the contract nature. Fourth, application of to the case. Applying these principles, the court found that the mistake in Hay versus MH was substantial enough to impact the contract core. The mistaken belief about the business assets value and operational status was deemed material, hence the contract was voidable due to the mutual mistake. This approach ensured fairness by preventing one party from being unfair bounded by a contract that neither truly understood. Conclusion. So, to conclude all of this, in Hay versus MS, Saskatoon Queen Breach discussion reinforces the doctrine of mistake in the contract law, emphasizes that mutual mistake about fundamental aspect can invalidate agreements. This cause highlights the importance of clarity and accuracy in contract negotiations, and the judicial system rules in rectifying agreement that fail due to such errors. So thank you everyone, and thanks to my team to make me the part of this great assignment. Thanks to all.